Respected court, may I proceed, sir?
Proceed.
In the Court of Judicial Magistrate Second Class, Raisen MP, Civil Suit number 23 of 2016. In the matter of Mr. Praveen, son of Mahesh, age 35, resident of Bareilly village, Raisen district, MP. It is splendor. Versus Mr. Sandeep, son of Suresh, age 36, resident of Bareilly village, Raisen district, MP. And with the government of MP through collector, the defendant. Final argument on behalf of the prosecution plaintiff in suit for declaration of ownership and also for the recovery of possession of the land bearing survey number 1011, area 8 acres situated in village Bareilly district, Raisen. The suit has been filed under section 5, 6, 31, 34 of the Specific Relief Act 1963 and under Order 39, Rule 1 and 2 of the Code of Civil Procedure (CPC). Key facts of the case are as follows: Mr. Praveen, son of Mahesh, age 35, is the only son of Mahesh, who is the son of Makhanlal, and was the only legal heir of the Mahesh. The said disputed property is the ancestral property of the father Mahesh. Late Mr. Mahesh, his father, was the owner as well as possession holder of the disputed property. After the death of plaintiff's father in year 2011, Praveen being the only legal heir of the deceased, Mr. Mahesh became the owner of the suit property. But defendant Sandeep, son of Suresh, age 36, in collusion with the revenue officers with the intention of usurp the disputed property, got mutated his name over the suit property through a forged will and dispossessed the plaintiff forcefully from the property. Both matters came to the knowledge to the Praveen about the mutation proceeding during the Diwali festival on 25/11/2011 and nothing before. And also when the defendant forcefully dispossessed the Praveen from the disputed property on 20/11/2011, which aroused the cause of action for the suit and filed in 2016. Thanks.
May I proceed on behalf of the defense? Proceed. Yes. Your Honor, as per plan, as stated, not fully admissible. The defendant submits respectfully his written statement in following points. First, that the fact is admitted that plaintiff is his cousin, brother, and the land bearing survey number 1011, area 8 acres, situated in village Bareilly, district Raisen. This is referred as suit property. That is, the suit property was not ancestral property as by colleague has stated in land that this is an ancestral property. This is not the ancestral property, but a self-earned property of my uncle, father of plaintiff. That is, the uncle had bequeathed the suit property to him through a registered will. Being happy and sound mind without any pressure, as being pleased with its services to him in his last days. This will was made on dated 1st September 2010, exhibited. That is, the suit property got mutated by revenue authority on producing the registered bill. As my colleague stated, this is forced and forcefully. It is denied. So, suit property got mutated by revenue authority on producing the registered bill after the death of uncle in year 2011. And the mutation process as per NBLRC is made, and after no objection received within the prescribed period in NBLRC section 109 and 110, the mutation was made. That is, the plaintiff never stayed with his father. Your Honor, this point should be noted that plaintiff never stayed with his father nor cared for him in his lifetime. That is the fact as stated in plain about state of mind is incorrect. Your Honor, whatever is mentioned is not correct and it is useless. The fact is that the bill was executed by uncle in sound mind, in happy mood, and in presence of two witnesses without any undue influence. Executed defense witness 2 and defense witness 3, who was the witness in bill. That is, the defendant is in possession of the suit property since 2011, and the suit property was purchased from his own earnings. This point, Your Honor, should be considered. Documentary evidence of registry is submitted here. That is, the suit is filed after 5 years of mutation process and possession. As my colleague stated, that he came to know this in Diwali 2011, but his case was filed in 2016 after 5 years. So this is time. To pray, that is, the defendant is the owner of the suit property and humbly prays to disallow the suit on the basis of proved will, and the suit is time barred. And case with support are Manu versus State of MP, High Court upheld, and then Supreme Court also upheld the decision. Second one, Vijay Singh Yadav versus Srimati Krishna Yadav, on dated 14th February 2025. Third, Jalandhar Puri Goswami versus Parmeshwari Giri. And Your Honor, fourth one is the Supreme Court decision Jitendra Singh versus State of MP. Honorable Supreme Court upheld the transfer of property by bill reported 2021 SCC online SC 802. Thank you.
Sir, the prosecution wants to take your permissions so that we can start evidences. So, first of all, the plaintiff, that is Mr. Praveen, in support of his claim,
for declaration of the ownership and recovery of possession has led both oral and circumstantial evidence to establish his rightful ownership, the fraudulent nature of the defendant's claim, and the invalidity of the impugned will. While documentary evidence regarding the testator alleged illness is unavailable, the plaintiff has adduced credible oral testimony, which is legally recognized form of evidence under the Indian Evidence Act, which is now also called as Bharatiya Sakshya Adhiniam 2023. Sir, whatever my colleague has said, I think it is very suspicious. There are various sort of lacunas in his statement. Let me introduce this quote by the first one. Plaintiff oral evidence. The plaintiff examined the plaintiff witness number 1, wherein he proved first-hand substantive testimony, first ownership by succession. He categorically disposed that suit property was ancestral in nature and originally belonged to his father. For this, upon the father demise, first the ownership by succession, the plaintiff categorically disposed that the suit property was ancestral in nature and originally belonged to his father. That is, upon father demise in 2011, as the sole class 1 heir, he automatically inherited the property as per the purpose and policy of the Hindu Succession Act 1956. The second lacuna which I have found in my colleague defendant's statement is regarding the forgery and the fabrication of a will. He disposed that the will allegedly executed on 1/9/2010 was a fabrication. He proved a detailed account of how the defendant exploited the absence of documentary evidences into the plaintiff case as per the Indian Evidence Act. We recognize oral evidence as primary evidence in the cases of these sort of things. Several judicial precedents are also there, and there are various sort of considerable Supreme Court and the Honorable High Court judgments which categorically state about this point. The first being the Indu Bala Bose versus Mahendra Chandra Bose, 1982, All India Report 133. The third and the one of the most important lacuna and the fault find which I have found in my colleague's statement is regarding the failure of the defendant to rebut the plaintiff evidences. Hence, rebuttal is very important. The defendant's witness testimony does not withstand any sort of legal scrutiny. Why? Let me introduce this quote. First, defendant witness 1 merely reiterates his self-interest. The defendant, while disposing in support of a will, merely reiterates his claim without producing any sort of independent witness. Hence, it plays a very important role to question mark the various credibility of the defendant. The second, witness W2 silent on the will's execution. The defendant key witness fails to confirm the execution of the will, significantly weakening the defendant's case, and by getting silent into the topic, the defendant also attracts the liability of Order 8, Rule 5, Sub-Rule 2 of the Code of Civil Procedure 1908, which talks about deemed admission. Third is the Section 68 of Indian Evidence Act. The burden of proving of a will is something which we call as it has to be proved beyond reasonable doubt by the defendant. Here, in this case, the defendant has a failure to prove the will beyond the reasonable doubt. Probability of the circumstances of preponderance of the probability is something which is not acceptable for a will in this court of law. Thank you so much.
Your Honor, as my colleague for prosecution stated, that this is the ancestral property, but no evidence of ancestral property has been submitted in court. On behalf of it, I have submitted registry of the property which shows that this is the self-earned property which is exhibited in court. And two witnesses in will is also produced in court for witness. So this is baseless to say that it is ancestral property and it was forcibly prepared. So, kindly permit to disallow this case.
Sir, by just saying that it was a mere self-acquired property does not play an important role to play to make the defendant case very strong. It has been held by the Honorable Supreme Court in various cases that if you want to prove a will, it has to be proved beyond a reasonable doubt. Here the defendant is unnecessarily making the burden of proof upon the plaintiff to produce the will. Hence I have submitted, the plaintiff has submitted vehemently that he is the class 1 heir of the father, and as per the purpose and policy of the Hindu succession in 1956, he is entitled to get the property by way of an interstate succession, which does not require any sort of proof. Hence, we vehemently submitted that the testator vulnerability fraudulently obtained a signature on the blank paper by the defendant and later converted the same into testamentary document and instrument. By only doing mutation does not mean that the defendant is the real owner of the property. Thank you.
Sir, regarding the defendant counsel claim that this suit is time barred, but it is not. I want you to refer to the page number 10 of the file. The suit is not time barred. The defendant falsely claims that the suit is time barred under the Article 58 of the Limitation Act 1963, which provides a 3-year limitation. However, the cause of action arose only when the plaintiff became aware of the fraudulent mutation in November 2011, that is Diwali festival. The suit was filed in 2016, which is within the limitation period. Considering fraud violates limitation as per the section 17 of the Limitation Act 1963. According to section 17, clause 1, para 2, the period of limitation shall not begin to run until plaintiff or applicant has discovered the fraud or mistake, or could with reasonable diligence have discovered it, or in the case of concealed document. In this case, the will is a concealed document which was not disclosed to the plaintiff. So until the plaintiff or the applicant first had the means of producing the concealed document or compelling its production, the time is not started, and the will is produced when the suit is filed. So it is not time barred. Regarding the case law, in K.K. Modi versus K.N. Modi, 1998 AIR SC 1297, fraud discovered later. In this case, the fraud is discovered later that extend the limitation period. And also there is a contradiction in defendant's case. The defendant's witness DW1 remained silent on the execution of the will, casting doubt on its validity. The defendant claim F, that is Mahesh, was of sound mind, but no medical proof has been provided. If the will legally executed, why was the plaintiff never informed about it earlier? Regarding case law, is Ramchandra Rambaks versus Champabai AIR 1965 SC 354. When suspicion surrounds a will, the onus to prove it is on the propounder, that is the defendant. So defendant has to prove beyond doubt. And also there is no two independent witnesses regarding the will which has been produced by the defendant. So I don't know why they are claiming that there is two witnesses who support the will, even though the defendant's witness 1 remains silent on the execution of the will. Thank you.
Your Honor, this matter is up to court whether it is within limitation or not. No comment on this. But as per the record, this is time barred, as I can. Second, this will is a proved will on the basis of witness, and no coercion or undue influence was imposed at the time of execution of the will. And as my colleague stated that no proof of burden, that proof of burden of sound mind of father goes to plaintiff, not on defendant. I have already mentioned in my written statement that this will was executed in very happy mood, in sound mind. No question arises of unsound mind. As per the section 2H of Succession Act, will is a legal declaration of a testator's intention regarding their properties transfer after death, who will inherit a person's assets after his death. As Your Honor, I have stated in my written statement, plaintiff never resided with his father. Even at the last time my client was caring his uncle, and with happy mood and with love and affection he executed this will. So there is no question of any forgery or any undue influence shown. So kindly disallow the case.
Sir, there are various point of suspicion in the colleague statement. The first being the well-settled legal principle that every person is of a sound mind until and unless he is proved of unsound mind. So the statement which was given by the respective defendant from my colleague that the burden of proving the mental condition of the father is upon the prosecution is totally baseless, because father was not in the fit mental condition, and the plaintiff affirmed unequivocally that his father was not in a fit state of mind at the time of execution of the impugned will. His father was suffering from age-related weakness which rendered him incapable of exercising the free will. As far as the plaintiff's assertions were further substantiated and independently corroborated by the witness, that is plaintiff witness number 2, who testified that the plaintiff father was in the state of physical and mental weakness, which had played a very important role to mark a testimony and oral testimony in the favor of the plaintiff, that by the help of oral evidence that the father was not in the fit mental sound condition, rendering him very much incapable of executing a will. There was no indication of the deceased having any intention to exclude his natural heir from the succession. Just because a son is not living with his father, just because a son is not having a good relations with a father, does not mean or does not negate the biological fact that he is the father. There are very short of conditions and there are very short of circumstances in which the father and the son is not having good relationship, but still by way of interstate succession, the property devolves upon the class 1 heir. So by only saying that the father was not having good soundness or good relations with the son does not negate the biological fact that the son, that is Mr. Praveen, was the biological son of his father.
Sir, I want to refer to the page number 8 that is mentioned. Section 63 of the Indian Succession Act 1995. A will must be executed in the presence of two witnesses and proven valid, And regarding reference case law is Jaswant Kaur versus Amrit Kaur, 1977, AIR 74 SC. If suspicion exists, the court must demand stronger proof of a bill's genuineness. And another case law is X Venkatachala Iyengar versus PM Thimmajama, 1959, AIR 443 SC. A person alleging a will must prove its execution and authenticity beyond doubt, and its execution is not proved or supported by the witness DW1 of the defense. He remains silent on such things. And in the end, I'd like to pray to the court, in the light of the argument presented, the evidence produced, and the legal precedents cited, the plaintiff humbly prays before this honorable court, for the following reliefs. First, the declaration of ownership. That is that this honorable court declare the plaintiff as rightful owner of the suit property. Cancellation of fraudulent will and mutation. Being fraudulent and invalid will be declared void ab initio, and any mutation in favor of defendant be cancelled. Third is recovery of possession. That the possession of the suit be restored to the plaintiff who has been unlawfully dispossessed forcefully by the defendant. Permanent injunction against the defendant. That the defendant be restricted from interfering with the plaintiff's peaceful possession and ownership rights. The plaintiff peacefully places full faith in the wisdom of this honorable court and prays for the verdict in his favor. Thank you.
So with this, I want to add one more point, that the plaintiff has filed a suit for declaration of ownership under section 36 of specific relief act, cancellation of the will under section 31 of SRA, and the recovery of possession under section 5 read with section 6 of the specific relief act. The defendant has not contended any sort of point regarding the illegal dispossession of the plaintiff from his property, which itself is very much unequivocal, that the plaintiff categorically stated that he was in a peaceful possession of the suit property from 2012, until 2012-2011, when the defendant forcefully ousted him without the due process. It has been categorically, vehemently submitted to the Honorable Court that the defendant does not have any sort of legal right. Neither the basic principle of the specific relief act allows the defendant to forcefully dispossess the plaintiff from the plaintiff house until and unless he proves beyond reasonable doubt and not having the preponderance of the probability that he was the rightful owner of the said property. Thank you.
In conclusion, Your Honor, I want submit respectfully that at the time of mutation in 2011, after the death of uncle, proper proceeding was followed as per MPLRC in section 109. No one has objected during that time, and after the process has been completed in prescribed period, that is 5 months, nobody has filed any objection in revenue officers or in court, and this case was filed after 5 years. After 5 years, that is 2016. So this is not sustainable, and as per the section 67 of BSA 2023, probate of will, that is legal process after the death, is propounded, and a person lawfully acquiring any right or interest in the land will be informed under section 109(3) as mentioned. So all the process has been followed, and after mutation he took possession in 2011, and after this fact was well known to plaintiff that possession has been taken by my client, taken by his cousin brother, that is my client. But he did not approach court in 2011, not up to 2016. So this shows that he was aware of the fact that neither he was residing with his father, not caring his neighbors, as a defendant witness was produced in court. He also admitted that plaintiff was not residing and not caring his father, and cousin brother was caring him at last time, and in love and affection and for caring, he bequeathed this suit property to his cousin brother. So this is the matter. Kindly disallow the case and make the title as
Sir, I would like to make sure that this honorable court looks on the page number 10 of the pleading. On the last para, it has been stated that according to section 17 clause 1 para 2, the period of limitation shall not begin to run until plaintiff or applicant has discovered the fraud or the mistake, or could with reasonable diligence have discovered it, or in the cases of concealed document. Here in this case, the plaintiff has taken due course of action just after the mutation proceedings, because it is only after the mutation proceedings where the plaintiff has discovered that what sort of fraud he has done. Until the plaintiff or the applicant of concealed documents, until the plaintiff or the applicant first had the means of producing the concealed document or compelling its production. I want to raise one important point here, that only by saying that we have done the mutation proceedings, no doubt the mutation proceedings was very well in the due courses of law, but it has been categorically submitted by the plaintiff side that in the case of Krishna Kumar versus Vimla Devi, All India Report 2011 Supreme Court, just because the defendant or the plaintiff has a mutation entries does not create or confer the title of ownership on the plaintiff or the defendant. No doubt the mutation proceedings was well within the due process, but the mutation proceedings was the after effect of the fraud or the forgery of that testimony which the defendant has done. Apart from this, just because the defendant is relying on the mutation proceedings, I would like to request the Honorable Court this kindly to take regressive action on the basis of the mutation proceedings. A fraudulent mutation does not confer any sort of proprietary rights and any sort of special rights. Apart from this, the defendant and my colleague has submitted that we have a sort of malicious intention while filing the case. I would like to submit that it is only after the mutation proceedings that the plaintiff has bring the attention of this case on the ambit of this court. Hence, the pleadings of the defendant is totally baseless. He is only arguing on those sort of topics which are not logically and legally related to this case. Thank you so much.